And who made the decision at some point prior to April 17th to seek indictments against Mr. Finnerty and Mr. Seligman?
I made the decision, I guess would be the best way to say that. I mean, we discussed it. The officers were in agreement to do that, but it was my decision to do that. I prepared the bills of indictment.
Do you recall speaking with I guess it's Detective Gottlieb about his questions about whether that was appropriate? Did you hear Investigator Hyman testify that he and Detective Gottlieb had discussed concerns, and it was his understanding that Detective Gottlieb had called you and expressed those concerns?
I did hear his testimony. I also recall that one of the issues that was raised in doing this was the question about, since everybody had said that Colin Finnerty was at the party, or at least some people said that, they weren't as concerned about that. But they were a little concerned about whether Mr. Seligman should be indicted because we did not have independent verification at that point that he had been at the party, although obviously subsequent information has shown that he was. So we did have that discussion. Yes, ma'am. It was, I don't know the precise time in which that discussion was held.
And then who would have made the decision to seek an indictment against Mr. Evans?
I made that decision as well.
Thank you.
Yes, ma'am.
One quick question, Mr.
Yes, sir.
Nifong. When you didn't get the results that you had hoped for from the SBI DNA test or from Mr. Mahan's test, I believe you made the statement that you were going to do things the old-fashioned way. What were you referring to when you, a layman, what were you talking about when you said the old-fashioned way?
Most of my experience in trying rape cases came in the era before DNA testing. And at that time, pretty much what you had was the testimony of the victim in the case and perhaps some corroborating evidence. Sometimes we would have forensic evidence under the old ABO system or something, not always, but so we'd be able to say, for instance, that there was the defendant was in the group, there was a 90% exclusion of people other than the defendant from a group or something along those lines. But often what we had was just the testimony of a victim about what had occurred, and there was no physical evidence that proved the identity of the perpetrator. Now, there are two generally kinds of rape cases. One is the lack of consent case, and the other is the identity case. And with identity, consent and identity. I mean, the two ways that either there was no consent, but the perpetrator is known, or in other words, the question is, since the victim knows the perpetrator, the defense is consent. In cases where the victim does not know the perpetrator, the question is usually one of identity, and we have to prove the identity of the perpetrator of the crime the same way you prove the identity of the perpetrator of any other crime, through eyewitness testimony and things like that. And that's to what I was referring.
Well, let me ask you this. In the old-fashioned way, where you had only the accuser's testimony, it was so old-fashioned you didn't have any DNA testing, right?
That's true.
Well, in here, it's a little more modern. You have the accuser's testimony, and then you have also DNA testing with no direct link. Think the old-fashioned way still works under that scenario?
Mr. Williamson, I do believe that any time that you have a victim in a sexual assault case who is allowed to testify before a jury that the person who's been accused is the person who committed this particular offense, then that is sufficient evidence for a judge to send a case to a jury. I believe I said that earlier, that if you have a believable victim in such a case, and you have enough to convince a jury beyond a reasonable doubt, doesn't mean that you will, but that you have enough to support such a verdict.
Would it be your policy today to indict and bring to trial a rape case based solely upon the testimony of the accuser. Any such case, that so long as you have an accuser who can identify a defendant and wants to tell her story, would you bring that case to trial?
I wouldn't say that I would bring any such case. I think that if you have that situation, you have to investigate the possibility of going to trial, and you have to discuss with the victim all the possibilities. I don't think that you can. I think you have to look at all the facts in the case before you can make that determination.
What facts in this case supported your conclusion that Crystal Mangum was sufficiently credible to go to trial based upon her word alone?
Well, I didn't think that the testimony was based on her word alone, in the sense that there would be physical findings from a sane nurse. There would be evidence that was consistent with post-traumatic stress. There was the fingernail involving Mr. Evans.
What importance did you place on that?
Well,
what did that indicate to you?
She indicated to me, or in her.
No, I'm sorry. My question now is, what importance did you place on that DNA evidence regarding the fingernails?
Well, I thought that it was important because it corroborated her statement about how the fingernails got broken off. That is, she said that she was struggling with an individual that she identified to a 90% certainty as Mr. Evans, and then when the fingernails were tested, the only DNA that was consistent with any of the players was his DNA.
Okay, go ahead. I think I interrupted you.
I have no idea where we were.
Well, I was asking you. Well, I think I got it. I got just one more question. Were you personally involved in the decision to prosecute Mr. El Mustafa?
No, sir, not in the decision to prosecute. We have a policy in the office whenever in the course of an investigation or something that we come up with an unserved warrant. It might be in the courtroom. It might be when we're running record checks on somebody. For me, sometimes it happens in traffic negotiations. Somebody come in to negotiate a traffic ticket and will want to deal with a traffic ticket, and I'll notice an unserved worthless check warrant. I said, well, I'll tell you what. You go show me this has been taken care of, and we'll deal with it. It's just a policy to get all those things served, to not leave unserved warrants in our system. And so when Mr. Wilson found that, he announced it to the officers that he found that, and they said they would go serve the warrant. The case came up in the normal course in district court. In this particular case, there was actually, I learned subsequently, video evidence from cameras both inside and outside the store. It was the case was several years old, and apparently, I'm not sure why it had not been served, but there was a spelling error or something in the name, and that could have contributed to it. But at any rate, there was sufficient evidence to try the case, and I don't have any recollection. I know who tried the case, but I don't recall talking to her about whether the case should be tried.
Were you aware that the warrant had been served and he was coming to trial?
Not immediately. I think at some point that I was made aware that case was up.
By the time of the trial, were you aware that he was being tried?
Probably either that on that same day. I don't know if it would have. I think that I probably knew that day.